Hey, good morning. We're now getting to the home stretch of this program, and I'm going to try and address what else. What else besides going to the Ritz-Carlton at Half Moon Bay can we do for in-house and outside counsel to help deepen relationships and build productive and long-term partnerships? And I know some of you are thinking no, there's nothing else. This is pretty much it. So you can end your presentation. It's going to be the shortest presentation on record at Trial Network. But I think there's more. And I think it starts with keeping in mind that corporate legal departments are considered cost centers. I've heard a couple times just this weekend from folks that one of the biggest concerns, obviously, that in-house counsel face is controlling costs. And that cost they're controlling is us, outside counsel, who are worth every penny and more for the work we do for them. So, what is the problem? But in all seriousness, how some clients are now reframing this issue and discussion is looking at whether or not they are receiving value from their outside counsel, or what has been referred to before as value-based legal services. But what does that even mean? How do you measure value other than outside counsel's win-loss record or, looking at that final number on the billing invoice? Those things are not unimportant, but there's more to think about. In fact, many of the in-house lawyers here in this room are already evaluating their outside law firms, either formally or informally, on a number of factors. But you may not always, stop and think about what those factors are and why they're important and how they're being demonstrated when you're working with your outside counsel. So I'm going to break down a number of criteria that have been used by my firm's clients when deciding whether the law firm is providing value to them. They generally look at 5 key things. They look at strategy, they look at quality, cost, communication, and collaboration. And I'm going to identify some of the ways that outside counsel can demonstrate value under each of these factors. I'm sure many of you in the room, outside counsel, are already doing these things for your clients, but this may serve as a good reminder of things we should be doing. All right, but first things first, being from Minneapolis, it would really be unforgivable if I did not have a Prince reference for a Facing the Music Trial Network theme. One of the many hits off the 1984 Purple Rain album, might actually reflect the relationship some of you already have with your in-house and outside counsel counterpart, or maybe you're just working towards this standard. But for the rest of us, we can go with another classic using some Rick Astley standards. So I bet you didn't think you'd get rickrolled this morning. So my husband was an IT professional, said I could tell the general age of the audience by whether or not they got that reference. But so while this is a pretty good list of tips for developing good partnership and maybe even value-based legal services, again, there's more that we can do. All right, providing value by strategy. One view of this means, how are you going to win a case? How do you get to the end result? Dismissal by dispositive motion, your favorable jury verdict, or win on appeal. But as Blondie says, you'll do that one way or another. And, outside counsel who can think of different or unconventional ways to approach cases, the so-called thinking outside the box, and be successful at that, are obviously valuable. Unfortunately, most of the creative types, didn't go to law school in the first place, and then, law school tends to systematically eliminate any creativity one has left, so you can, start to think like a lawyer. But creative and innovative ways to win cases or find solutions for a client are always going to add value, no matter, how left brain dominant we all are. And providing value with strategy also includes really understanding and knowing your client's business, their objectives, their priorities, and the risk tolerance, so you can make an informed, case strategy decision. The way you approach a case, if you have a client who never ever wants to take a case to trial, and they're out there, is going to be a very different way to approach a case than if the client is not afraid of trial. When you decide whether you want to bring that IP case, can the client accept the risk that their IP might be invalidated, which is going to kill all the licensing revenue under that it brings in. Does the client have other effective ways to address that competitor, that competition in a lawful manner that isn't going to involve litigation. Those are things that outside counsel can help and create innovative solutions and ways for clients to address these issues. Or maybe you have the best legal case in the world to bring against a former employee for breaching their employment agreement, but it's going to bring a ton of negative publicity, or it's going to damage the goodwill with the key customer or vendor. And the good outside counsel is going to help look at the pros and cons of that, of bringing suit in light of those business concerns and priorities of the client. And looking on the defense side, do you have a plaintiff's law firm that is bringing repeat cases, who's going to need an aggressive approach to discourage them from filing lawsuits? We're not an ATM. You're going to have to do work in this case if you want to get any recovery. Or does your client need a quick and early settlement for a case because it's holding up a business deal or a merger? Or is there only going to be money to pay for a settlement? That's only going to be available in a particular fiscal quarter. These are all things that outside counsel should understand so they can align the client's business priorities and needs with strategy. Another way outside counsel can provide strategic value is by developing what you might call a litigation playbook for a particular type of case or legal issue, especially ones that repeat in a client's particular industry. So that can cover things like key arguments, or legal positions or defenses that you want to pursue and how they're going to be supported in the case. What are the key documents that are going to support that? Who is going to tell the client's story? Who are the key witnesses? What's your strategy for motion practice? What's your standards for bringing a motion to dismiss or an early summary judgment motion? What's the key discovery you need from the other side to support those motions? And what's the discovery you need to collect from your own client? And are those parameters and how you collect going to be defensible? This type of playbook just needs to be continually reevaluated and updated to incorporate, what's worked or what's working, and also, just what maybe isn't going so well. The point of having a plan like this is not to become predictable, but how you approach a case or how you litigate for a client, but it's trying to be efficient, and it's trying to make sure you're not reinventing the wheel unnecessarily if you don't have to when you have common cases. And you definitely do not want to be like Brittany and repeat mistakes that are avoidable with a little bit of careful thought. But this kind of intentional planning, a consistently executed litigation strategy is particularly important if the business objective is something really big picture, like establishing precedent or changing, on the flip side, changing unfavorable precedent. For example, preemption is a big issue. These are ways to make real impacts, measurable impacts for a potentially large number of cases that your client might have. The kind of, even if your goals aren't that lofty, you can still benefit from a coordinated litigation strategy by allowing outside counsel to do things like track testimony of company witnesses, opinions of testifying experts who are going to be repeating in future cases, so they can avoid those, pesky credibility, impeachment issues from inconsistencies. That kind of tracking also allows you to quickly identify, which witnesses have the knowledge you might need for a particular deposition, or whether or not the witness is going to be a good testifying witness at trial. And we just heard about how important it is for the right company witness to be at trial. And outside counsel can help assess and track those things for our clients. Outside counsel also, we all have those work product databases with model pleadings and written discovery for similar matters that we can leverage. We can also help with consistent ESI protocols for document collection, so you don't have to keep recollecting documents on a different standard every time a new ESI order protocol comes in. That's an unnecessary and preventable cost that can be prevented with a consistent ESI protocol. And consistency in document production is also really taking more significance as we see plaintiffs' counsel sharing with other plaintiffs' counsel their understanding of what kind of documents a company has and what they should be producing. So, identifying a core set of documents for a client that can be produced in multiple cases to avoid, inconsistencies from case to case, and then also already knowing what the issues might be with those documents is something that outside counsel can do and can provide value through strategy. All right, providing value through quality. Okay, quality is not just having excellent work product, pleadings and briefs, being able to prepare witnesses, work up your case for trial. All those things are obviously important and need to be done, and they're really just sort of minimum standards. Quality also is, having the expertise and judgment to really accurately analyze and assess a case. What are the case's strengths and weaknesses? What are the issues and key challenges? How long is it going to take before the case gets resolved? What's the likely exposure or outcome, either by settlement or jury verdict? There are a lot of predictive modeling tools out there that are harnessing big data, either from firms or from court filings to help answer, how long a case might take to resolve or its likely exposure, which are usually the two issues or questions that the client or business are most interested in. And the legal analytics companies have really done a pretty impressive job of creating programs that take all this data and allow you to use a search tool for it. They've taken, for example, all the pleadings and results off PACER. You can do a search by specific judge, motion, and case, and find out pretty accurately, the statistics on how the judge ruled on a particular type of motion, how long that type of case took to get to summary judgment or trial, and jury verdicts. So outside counsel should be leveraging that kind of information for clients. But what data analytics can't replace is where they can't replace humans, and outside counsel is really understanding jurisdictional nuances. So your outside counsel can provide value by, they've tried several cases in front of a assigned judge you have who knows and respects them, or they have a lot of experience and a good working relationship with opposing counsel that's going to allow you to have productive settlement discussions and avoid disputes if opposing counsel really trusts and respects your lawyers. And finally, quality really also includes when outside counsel is acting as a real partner in their client's business. You're working together to provide information the client needs to make business decisions. You're, advising on settlement value. You're providing, predictable legal fees and costs. These are all things that are important to the client. And so they should also be important to outside counsel. These are shared concerns. They're not just in-house counsel's concerns. All right, cost. Trying to cover the music range here with between Destiny's Child and AC/DC, but cost is usually the one thing everyone focuses on when deciding whether outside counsel is providing value, which can be a little short-sighted because you still need to look at what are you getting for that spend. If you have an antitrust expert who's litigated a ton of cases against or negotiated with the DOJ on antitrust issues, representing your business in their antitrust case against the DOJ, that attorney is providing you value even if their billing rate is going to be 40% more than the typical counsel that you're using in your cases. And I'm not going to go into all the ways you can structure an AFA and do those things, but what's going to be cost effective is going to be different, depending on what kind of case you're dealing with. You've got your low value commodity run-the-mill cases. You have on the other spectrum bet the company litigation. Then you have got everything in the middle, and that middle is pretty big. So there's any number of ways you can rate size fees for a particular case or portfolio of cases or claims. And based on past experience, law firms should be able to assess what do they need to charge for a matter or matters and still, be profitable. That's the goal, that both sides benefit. And don't forget that AFAs can be broken down into their component parts. You can do it flat fee by deposition, by motion, by defendant fact sheet, in combination with a larger fee arrangement. One word about using legal practice management and legal ops folks, a lot of in-house departments and law firms are now using these professionals, and they can help make sure that fees are staying within budget or within an AFA, and maybe why they're not, and addressing those things and doing it in real time, because by the time the attorney gets that statement at the end of the month that's got the bill, there's really not much that can be done about it at that point, except maybe doing, a write-off. And, obviously part of the cost equation is figuring out, how close are you to budget when you are done with the case. So use your legal ops folks. Okay, communication. Now, if we could only all pick up the phone and Adele was on the other line, we quickly return all our calls. But, we know it's important to keep clients informed on what's happening in a case and give them the heads up on decisions that they need to weigh in on. And we know it's important to raise these concerns and issues early and often. And, while it sounds really easy, communications is an area I think everyone can improve. A lot of it has to do with the fact that we're so, busy and we're under an avalanche of emails, so we're not always connecting with people in ways that we'd like or as quickly as we'd like. But, one of the most important things about open and regular communication is to avoid surprises. There was a piece of advice given by the GC of a Fortune 200 company about communication that I think is shared by a lot of in-house folks. And he said, you can bring me good news, you can bring me bad news, but never ever bring me a surprise. And this was in response to being told of a six-figure legal fees cost overrun that wasn't raised early. Don't be that outside counsel. We all had things that have happened that have gone sideways in a case, but the first, contact you should be making is with your client to advise them, what's happened, how are you going to handle it, how it's going to affect fees and the budget. And a quick word about feedback. A lot of times we will do a post-mortem review of matters where we'll look at what went well, what didn't go well, why did that happen, how could we improve this in the future, were there specific issues with witnesses or documents or decisions that were made. Get feedback from in-house counsel and their business partners and stakeholders to find out what they thought. The point of post-matter review isn't isn't to criticize, it's how to replicate favorable outcomes and how to work better together in the future. Collaboration, last but not least, collaboration is the key to a strong relationship. This is really about investing long-term in clients and counsel from outside clients. So this should be a business relationship. When you partner, outside counsel is finding out what the client's pressing needs are and figuring out, okay, are there things that we saw in cases that we can advise you to help your internal processes? Is there competitive and industry news that we can give you that would be interesting? Are there, education, training, CLE programs that we can provide? Are there pro bono opportunities where we can partner and work together? Maybe you would like to have someone seconded at your company from us. Are there ways we can collaborate and work with other outside law firms you have on common cases so we can share ideas and strategies? These are all ways to collaborate. So, hopefully you have been reminded of some ways outside counsel can provide value to our clients, how to develop long-term, mutually beneficial relationships. And so even if inside counsel can't say, I would die for you, you hope they can at least say that, everything is awesome. Thank you.